Hi everyone, I'm maritime personal injury attorney David Saltaformaggio. I previously discussed the question of what constitutes a vessel for the purposes of qualifying as a seaman. Again, this seems like common sense, but I wanted to give a few examples of court decisions that demonstrate that the question can actually be rather complicated under certain circumstances. Barges, for example, are considered vessels even though they have no means of self-propulsion. Dry docks used in vessel repair and construction, on the other hand, are not considered vessels because they are typically permanently affixed to the shore and are not in navigation. Another difficult question arises when a vessel has been taken out of navigation. The answer usually depends on whether the vessel has changed so much that it no longer has a navigation function. For example, a steamboat that once sailed but had the engines and boilers removed was found not to be a vessel. However, a vessel that was taken out of navigation only temporarily for repairs is still considered a vessel. Specialized structures used in oil and gas production cause perhaps the most confusion. For example, semi-submersible drilling barges and oil storage barges have found to be vessels. However, fixed oil and gas platforms are not vessels. As you can see, whether or not a structure is a vessel is not as straightforward as it may seem. But this determination plays a huge part in determining your rights and remedies. So it's important to hire a knowledgeable maritime attorney to help fight these battles for you. In my next video of the Seamen's Rights and Remedies series, I'll discuss your rights to assert a claim for negligence against your employer under the Jones Act. Thank you.